Hi, my name is Dan Krause. I am an estate planning elder law attorney in Wisconsin, and today I want to talk about some of the things that can go wrong if you do your own estate planning. I have a law office called Krause Estate Planning and Elder Law Center. We are in Madison, Wisconsin and Oregon, Wisconsin. So some of the things that can go wrong if you do your own estate planning. And I know some people like to do their own estate planning, and we want to help those people out. But I just want to give you some maybe cautions about things to look out for if you are doing your own estate planning. So things about filling out a form will or a form power of attorney or something that you find on the internet, or if you want to draft up your own things, things can go wrong. Now, a will can be very simple. In fact, as long as you write something down that you want to have happen after you've passed away, and then you sign it in front of two witnesses, in Wisconsin, that's going to be a legal will. Now, long ago, I learned that the shortest will on record was 3 words, and it said, "All to mother." That was a legal will wherever it was done. It wouldn't be legal in Wisconsin because it didn't have a signature and two witnesses. But in, say, Nevada, that could be a perfectly valid will as long as it was in the handwriting of the person who made the will. That they did it with, in their own hand. In Wisconsin, you could do all to mother, and then you'd have to put your name, your signature, along with two witnesses, and that could be a valid will. But you can miss some things if you do simple planning like that. And one of the things is alternate beneficiaries. So what if your mother had passed away before you did? Now your will is useless because all it says is all to mother. It doesn't say anything about alternate beneficiaries. So just be careful about alternate beneficiaries, and always think, what would happen if me and mother were in the same car and we crashed? Who would I want to get my stuff next after mother? And then you can write that in there. You could say, and if mother has predeceased me, then I want the share that would have gone to mother to go to brother or sister or niece, nephew, aunt, uncle, whoever. Another thing that usually is not taken care of by simple wills is, what if you have an estate that's taxable? What if there's going to be a lot of money there that needs to be taxed by the IRS before it passes to mother? This will doesn't have anything to say about that. And there are certain things that can be done in order to minimize taxes before everything goes to the mother. I won't talk in specifics about that because it gets rather complicated in using trusts or family limited partnerships, etc. Another thing that this does not cover is long-term expenses or long-term care expenses. What if you, before you die, happen to become incapacitated, or you're suffering from Alzheimer's or some other debilitating condition that causes you to need nursing care? This will is not going to help protect your assets from that. So, in fact, most do-it-yourself planning has no ability to help protect assets. So to make sure that there is something left. So it just says, if there is anything left, it goes to mother, but the plan doesn't have anything to say about trying to make sure that there is something left. So planning for long-term care expenses, and we'll talk a little bit more about that in a minute. There's nothing about disabled beneficiaries. People don't realize sometimes that if mother is disabled at the time that you die and you plan to give everything to her, she may be qualified for Medicaid at the point that you pass away. She might be in a nursing home, and that fact could cause your gift to her, her inheritance, cause her to be knocked off of the Medicaid, and then she would have to spend all your inheritance or her inheritance from you on her care before she could get back on Medicaid, and then everything is just gone down the drain to very high cost of long-term care expenses. So be careful if you're doing your own estate planning that if you have disabled beneficiaries, that they would get something like a supplemental needs trust or a special needs trust instead of just getting the assets coming straight to them. Um, Another subset of that is a disabled spouse. So a disabled spouse, if they survive you, should always be taken care of with a special needs or supplemental needs trust instead of the money just going straight to them. It could do more harm than good. There's no plan for generation skipping transfer taxes, depending on how much you have or how much you plan to have when you pass away. This may also be a concern. Do-it-yourself type wills and powers of attorney do not generally have capital gains tax planning. Your CPA can tell you a bit about that, but the normal will all to mother would actually have a decent capital gains tax plan just built right into it because of the federal law allows for a step up in basis on the death. But some people, when they're doing planning, give things away before death, and that can create more taxes for the person that you're giving the assets to if you're not careful. Probate avoidance. Some people who do their own estate planning try to plan for probate avoidance by using powers of, by using pay on death, POD, beneficiaries on all their bank accounts, all their investment accounts, making sure that they have beneficiaries designated on any of their documents that control life insurance, etc. To make sure that there is nothing left in their estate when they pass away that can go through probate. There are issues with this type of planning in that it can cause family disputes about who's going to pay the bills that are left after you've passed away, leaving nothing in your estate to pay your bills with. Your children who have gotten all, or your children or your family who have gotten all the benefit of the PODs are going to be legally liable to pay your bills and pay for your funeral. But if you've got more than one person like that, I'd beware, because I have seen it almost in every case where one person is willing to chip in their share and one person isn't. Or if you have three, there's always one that is going to dispute the cost of the flowers at your funeral, etc. So leaving nothing in your estate is sometimes a formula for disagreements after your death about what type of funeral and who's going to pay for it, etc. Most do-it-yourself estate plans don't have anything to do with saving assets in case of long-term care. This is one of the biggest concerns of many of my clients, is what happens if I end up in a nursing home? Will all of my assets go away? Medicaid planning must contemplate gifts, or must accomplish gifts, typically gifts to an irrevocable trust. Although a gift to a person outright can do the same thing. Basically, if you have nothing at the time that you should need long-term care, then Medicaid can step in and take care of the cost of long-term care for you. So planning to have nothing is not as easy as it sounds, but if you do it the wrong way, you can set yourself up for penalties. If you give your things away to children, expecting that they're going to hold on to it for you in case you need it later on, which I see some people doing. It's not always a bad plan, but you never know what's going to happen. Things that can go wrong with a plan, like giving your assets to your kids, are what if the kids get divorced? Are your assets now going to be split between your child and their spouse? That's a very real possibility. What if your child has an issue of their own? What if they have medical bills of their own and they have to go bankrupt in order to pay off those medical bills? The bankruptcy is going to trigger the the bankruptcy court grabbing the money that you had given them, but now it's not going to be available for your security. If your child gets sued because of a car accident or something, your money could be gone to pay off that lawsuit. Or a child who just doesn't have their heart in the right place, or maybe just doesn't have their mind in the right place, could either just use the money for their own uses or mismanage the money in a way that makes it disappear. Also, just any time that you give away assets in contemplation of not wanting to spend them on nursing expenses can create a penalty period. And so you have to be careful and know about what the penalties are for doing that, and watch out for the 5-year look back period. So if you do create your own irrevocable trust to avoid some of these problems, just be careful that you allow for your tax step up in basis. So any assets that you transfer to your trust, you have to have the right provisions in the trust in order to allow the assets to step up in basis, so that your beneficiaries, when they receive it, they don't have a big tax bill waiting for them if they want to sell the assets. Also, who's going to pay the income tax on the assets in the trust? So if the trust is gaining income, let's say from a rental property or from stocks and bonds that are creating dividends or interest, do you know who's going to be paying the taxes? Is your trust set up properly to pass through the taxes to the person who created the trust, or is it going to be taxed at the very high trust tax rate? And that all depends on how you write the trust. Who will be the trustee? That's always a very, very important question. If you want to put yourself on as your own trustee for an irrevocable trust, that is usually a very bad idea. So you must find somebody that you really trust in order to be the trustee of your trust. Something to take care about. And can you change the distribution? So let's say you set up one of these irrevocable trusts this year, and then 5 years from now, God forbid, one of your kids passes away or just moves away, gets married to someone who doesn't let them contact you. I've seen these situations. And sadly, you want to divert the money that would have been going to them to one of your other kids or a grandchild or something. With an irrevocable trust, you have to make sure you put the right language in there that gives you a power of appointment on your death to give those assets to some other descendant of yours. This will still allow the assets in the trust to be protected, but they are not then completely nailed in, and you can't change the beneficiary. You want to have that power of appointment so that you can change the beneficiary as time goes on and your wishes change. So these are some pointers, some pitfalls that people who do their own estate planning may run into. And please, if you are doing your own estate planning, look further into these issues. You can find more using the magical tool called Google that can maybe help you further with more specifics. But if you are the type of person who is a little worried that you won't get it all right, we are very happy and prepared and able to help you with your estate planning. If you live, especially if you live in Wisconsin, Minnesota, or Illinois, we're licensed to practice in those states, and we know what we're doing. We've been doing this for 20 years and help many people get a very well thought out and effective estate plan. So give us a call if you would like, 608-268-5751. That's Dan Krause at 608-268-5751. Hope to hear from you soon.